Welcome back to Canadian Justice, where we're discussing the case of Alawalia and Alawalia headed to the Supreme Court about the new tort of family violence. Now, Stefan, the Court of Appeal of Ontario took issue with the lower court's creation of this new tort, family violence. So maybe you can walk us through some of the Court of Appeal's reasoning about why they thought that this was not, that this new tort should not have been created this way.
Right. So the biggest issue with this case was that the novel tort, the Court of Appeal found, and frankly, I think it's implicit in the trial judge's reasons that she also found, that there was really no reason to recognize this tort, especially on the facts of the case. So the judge at trial found that this new tort of family violence was actually overlapping on the facts of the case with existing tort called intentional infliction of mental suffering. So that existing tort was made out. There was really no reason to create this new tort of family violence. And this is essentially the line of argument that the Court of Appeal accepted, saying, well, you can't just create new torts because you think that this is an issue that is, perhaps of particular social importance, but there are already mechanisms in place under existing tort law that provide the victim here with redress. So why would you go about creating a new tort?
No, Anthony, one of the things that I've spoken to some other family lawyers about in this case, and we've done other episodes about this case, and that I've heard is that, and it was in the reasoning too at the lower court, that this is in part about the streamlining of processes, that having simultaneous claims for the existing tort of infliction of emotional harm, or just having a separate claim for civil damages simultaneously with your family law claim. I mean, it's a burden on the courts, it's a burden on the individual litigants in the case. It's better to streamline the process. What insight can you give me into that experience as a family lawyer, as well as what the courts have said about this?
I think it makes practical sense that you would just have all of those issues dealt with in a single proceeding. From the litigant's point of view, that person who's making the claim is not likely to have the resources to pursue two separate court proceedings. Oftentimes, legal aid, if they're on legally aided, wouldn't fund a civil proceeding necessarily. And as we know, the courts are backlogged, like in Superior Court of Justice in Brampton, where Justice Mandani sits, you're looking at dates a year down the road. So, like, let's just cut to the chase and be done with it. I think the cynics will say that this is going to open the floodgates, and I think that was something that counsel for the father said during the trial was that this is going to open the floodgates for everyone and their brother to just make these non-meritorious claims of family violence. But if you read the decision closely, it was a pretty high test. It's not just any sort of claim of domestic violence. There has to be credible evidence. It has to be repeated, and so on. So I don't think there should be any meaningful concerns about that. It makes sense. Having said that, in my practice, it almost never happens. I've rarely had files where anecdotally that you would raise a tort claim. So this could be helpful perhaps for the family bar who maybe aren't as familiar as the personal injury bar or other civil litigation practitioners with torts and how to quantify damage, so on.
Stefan, I mean, I do understand from a practical point of view this concern about streamlining processes. But is it necessary to recognize a new tort in order to achieve that streamlining goal?
Well, no. The Court of Appeal, and I don't think this was particularly controversial on appeal, really, the streamlining of the process. The Court of Appeal affirmed the trial decision on this point. And, there's some possible issues to work out, but I think it just makes sense on a procedural level that if you're bringing a claim between the same parties, that if one of the parties has a tort claim, that claim should be brought in the context of the same court proceeding. You don't need to recognize a new tort to do this. And the Court of Appeal was pretty clear that you could bring existing torts, so assault, battery, intentional infliction of mental suffering, and other things in that context.
So we've got about 30 seconds left. One of the things the Court of Appeal emphasized, Stefan, was the priority given to statutory claims over tort claims. What effect do you think that had on the outcome?
In this case,
Yeah.
none. None really. In other cases, it might, though the court's pretty clear, I think, that tort claims are different from, say, claims in contract or claims in property, which overlap directly with the statutory distribution of property scheme that we get under the Divorce Act, right? So for the most part, I don't think that this is going to be an issue.
We've got to go to commercial break now, but we will be right back. And we're going to be discussing how findings of abuse in family law cases differ from the criminal law. We'll be right back.